I am doing that right now. Let's see.
Perfect. Yes, and I see the recording. Sorry about that, folks, but I do see we had a few more pop up during the recording confusion, but I do see that we're recording now, so we will go ahead and get started. Hello to this great group. I see lots of familiar names, but a few new names in the crowd. But it is awesome to have you all here this afternoon. I know you've had a long day of teaching your classes, so we are so happy to have you here. For those of you who don't know me, my name is Tara Acquia, and I am the K12 Programs Coordinator here at the Arkansas Center for Research and Economics at UCA in Conway. So, in my role, I work with scholars, normally at the university level, but we find educational partners who are doing really cool, interesting work. And I work with them to create curriculums, programs, and events like this for teachers around Arkansas. So, some of you, if you've been in my past talks and webinars, know this, but the goal for the curriculums that ACRE and that I work to provide for you, my goals are that these are hands-on or interactive things that you can either be using, having discussions about, watching. My goal is that the programs are differentiated, so lots of different students with different learning needs are able to find the materials accessible, and of course that the materials are interdisciplinary in scope. So I know a lot of you you might be teaching US history this semester and economics next, and then 2 semesters from now, you'll be doing geography or personal finance or any of those classes. So our goal with our programs is to really make sure we've got that nice umbrella of topics and materials that you can use in all of those classes. So, just a little bit about your presenter today before I turn everything over to him. Mr. Justin Pearson is a senior attorney for the Institute for Justice. So, IJ is a law firm that has litigated hundreds of cases, including 9 before the Supreme Court of the United States. Pearson has litigated cases here in Little Rock, Arkansas, on behalf of an entrepreneur there that he might talk more about today. But today he'll really focus on how he litigates cases at the state level. So we'll take a look at state constitutions, maybe compare those to federal. How are the laws and structures different? And how can lawyers or people working like Justin, how do you use that knowledge of constitutional law to successfully defend your case or your clients in court? So I'm really excited for y'all to hear him talk today. He has given public talks all over Arkansas, I know in Little Rock, here at UCA in Conway for our students, and also some students down at the law school in Little Rock. So we are happy to have him in front of an K-12 audience today. I'll go ahead and turn it over, Justin.
Thanks, Tara. I really appreciate that generous introduction. And everyone, just so you know, um, please feel free to ask questions. You could type them into the chat, and I'm definitely going to leave time at the end to get to them. That's often my favorite part of the talk. I have one of the greatest jobs in the world. I wake up every day and I sue the government. It's a lot of fun. I am a constitutional lawyer for a public interest law firm. What that means is I never sue for money and I never charge my clients anything. Instead, thanks to our over 8,000 generous donors, I travel around the entire nation filing cases pro bono, asking judges to throw out unconstitutional laws so that my clients can start their businesses or grow their businesses or say what they need to say on their commercial signs, things like that. IJ does, where I work, we do quite a few different things, but I focus on representing small business owners. And there's no place better to do it than where I work. The Institute for Justice is the nation's largest philosophically libertarian public interest law firm. Now, we're entirely nonpartisan. We represent people from all different backgrounds and worldviews. We also sue Republicans as much as Democrats. It turns out that violating the Constitution tends to be a bipartisan endeavor. But we do have a guiding philosophy, and that's to provide free legal assistance to people whose constitutional rights have been violated. We're the largest firm of our type with our worldview. We have over 150 employees. We have 7 offices around the nation, and we litigate from coast to coast, even in states where we don't have a physical office, like in Arkansas. And I'm really excited about this topic today because I think state constitutions are ignored far too often. Oftentimes when I tell people that I'm a constitutional lawyer, They want to talk about the US Constitution. That's great. Like, I love talking about the US Constitution, but I actually have more cases under state constitutions than I do under the US Constitution. And that's not an anomaly for me. Like, that there are just more constitutional challenges brought under state constitutions than under the US Constitution. And it's not given enough attention. And so what we're going to do today is we're going to talk about the differences between state constitutional law and federal constitutional law, both generally and as it pertains to Arkansas. And really, the reason why I know so much about Arkansas constitutional law is because of this friend of mine named Ken Leininger. And by the way, if my head gets in the way of any of these slides, you can't read anything, don't worry. We're going to send the PowerPoint around afterwards. You don't have to worry about writing it down or anything with this. But this is my friend Ken Leininger. I represented him in the lawsuit in Little Rock that Tara mentioned. Ken just wanted to start his own business. He was a taxi driver for a yellow cab for over 8 years. And one day he decided that he left on good terms, but he wanted to pursue the American dream. He believed that he really wanted to have his own business. He didn't want to be an independent contractor for Uber or Lyft. He wanted to have his own little taxi company with electric vehicles that he thought would be good for the environment. He was just really excited about being an entrepreneur. So he starts his own taxi company in North Little Rock. And then shortly thereafter, he applies to expand his business into Little Rock. And so he goes and he talks to the members of the Little Rock government, a division of it called Fleet Services. And they tell him, basically, Ken, there's good news and there's bad news. The good news is you meet all of the requirements. You have everything you need to start your business. The bad news is it doesn't matter because Little Rock has a city ordinance that says no one is allowed to compete with Yellow Cab. Now, Yellow Cab is a private company, but it doesn't matter. Little Rock has created a monopoly for Yellow Cab. No one's allowed to compete, Ken, even though you're well qualified. Too bad we can't grant your application to operate in Little Rock. And of course, Ken was infuriated. Like, this is ridiculous. They admitted that he was qualified and they just said that no one was allowed to compete. And so he appealed to the Little Rock City Council, I believe it's the Little Rock Board of Directors, they call it. And the same thing happened. And in fact, some of the members of the City Council were shocked that they had created this monopoly for Yellow Cab, but the city attorney told them that that's what the city ordinance said. And so no matter how much they wanted to help out Ken, they were required to deny his appeal and bar him from competing against Yellow Cab. One of the cool things about working for a national nonprofit law firm is we actually have some cool videos and we have people who aren't just lawyers who work with us. And so I actually want to show the video because we actually have a clip. All of these government meetings are recorded. And there's actually a clip of the government official talking about how and expressing her disgust at how the city had set up a monopoly for a private company called Yellow Cab. I'm going to try playing this. Hopefully it won't be too choppy. If it is, then I won't show the second one later. Let's see here. Where did it go? Hold on, I didn't share it, did I? Let me try this again. Always an adventure. Here we go.
There you go, that worked.
We have allowed one company to have a monopoly in the city of Little Rock, and we've essentially said nobody else can have a cab because this one has 117 license permits. It's permitted to have 129, and we don't feel that we need any more. If nobody else can do business but that one company.
That's correct, Director Wright.
At the city board meeting, one of the board members admitted that Yellow Cab does have a monopoly. They voted, and they voted unanimously not to give me any permits. My name is Ken Leininger. I live in Searcy, Arkansas. I was a Yellow Cab driver for 8.5 years. About a year ago, I started Ken's Cab. We're operating in the Little Rock area, but the city of Little Rock has not allowed me to have a permit. It doesn't seem right that the government wants to tell me that I can't have a taxi service when I know that I've fulfilled all the requirements and more. I teamed up with the Institute for Justice because they gave me hope that I could have a business here in Little Rock. We're filing a lawsuit to break open the monopoly of Yellow Cab. Well, if Yellow Cab continues to be the only taxi service in Little Rock, they can get away with doing whatever they want to. The market should determine how many cabs there are in the city of Little Rock and which cab service they want to use rather than the government. I've worked all my life, tried to support my family. This is my American dream.
So I thought that was outrageous. I mean, the government admitted that he met all the requirements, admitted that they created a monopoly and said, you know, too bad. So we agreed to get involved. And frankly, the reason Ken's Cab is operating today and the reason we won was because of a provision in the Arkansas state constitution that doesn't exist in most state constitutions. And so what I'd like to do now is I'd like to kind of talk about state constitutional law generally, especially as it relates to, you know, federal constitutional law. And then at the end, what we'll do is we'll take those lessons that we've covered and apply them to Ken's case to show why Ken was able to win here when he probably would not have won his case if he lived in most states. And so I know a lot of you are teachers, a lot of you probably know some of this already, but just to make sure we're all starting at the same place, here's just some very brief background about constitutions in general. As hopefully most of you know, constitutions provide the people's rules for their government. People, you know, we have to follow the laws, but the government has to follow the Constitution while making those laws. As far as constitutional law is concerned, constitutions are considered the direct will of the people. Laws are just considered the will of the people's representatives. Anytime the will of the people's representatives, in other words, laws, conflict with the direct will of the people in the Constitution, those laws are unenforceable. And so that basically what I do is I go around to courts and I tell judges that this law conflicts with the Constitution, therefore it's unenforceable. If you're more interested in that and kind of the history of that and discussions about that, there's a great discussion in Federalist 78. Hopefully many of you have read the Federalist Papers. Federalist 78 is my personal favorite. It's also the one that's been most often cited by the US Supreme Court, and that's because it's really the one that talks about the role of the judiciary. And in it, Hamilton talks about how when there's a conflict between a constitution and a state law, quote, the Constitution ought to be preferred to the statute, the intention of the people, to the intention of their agents, end quote. And so that's basically just how constitutions work in general. Hopefully we're now all up to speed. Most of you probably knew this already. Now let's talk about state constitutions. So I think one thing that's really fascinating about state constitutions and is often overlooked is that they actually predate the US Constitution. Of course, not for all of them, because some states came later, but at least the state constitutions for the original 13 states predate the US Constitution. Of course, we had the Articles of Confederation for a while. And so by the time the US Constitution was drafted, we already had these state constitutions to look at. And that's what the founders did. They relied heavily on those state constitutions. They imported quite a few parts from various state constitutions. One example, since I'm a lawyer, I'm well familiar with the judicial power. The majority of those 13 original state constitutions had the judicial power. It was understood to mean that the state judiciary could rule state laws unconstitutional. And so the founders, the framers of the US Constitution just copied that term of art verbatim. Also later on, when a Bill of Rights was added, and you know, most of you know, your high school teachers, right? You know that there was a debate between the Federalists and the Anti-Federalists, and as a result, the Federalists agreed to add the Bill of Rights demanded by the Anti-Federalists. Well, the first 8 amendments in the Bill of Rights were copied verbatim from provisions in state constitutions. And so, you know, these state constitutions, they had an original, these original state constitutions had a huge impact on how the US Constitution was drafted, the provisions that were included in it. And so often we view the US Constitution as being this thing that just kind of was created by the founders as if they didn't look at other materials, but oftentimes they looked at the state constitutions. And of course, as most of you know, originally the way it worked, right, was the US Constitution was only supposed to restrict the federal constitution, right? The federal government was much, much smaller back then than it is today. The state constitutions already existed. Most people had more interactions with their state and local government than with the federal government. They were protected against state and local government by their state constitutions, at least in theory. And so the federal constitution, other than some exceptions like the Contracts Clause, the federal constitution was only supposed to limit the feds because you didn't need it to limit the states. We already had state constitutions for that. Speaking of things copied from state constitutions, every state constitution has its own version of a Bill of Rights. Most of them call them declarations of rights. You can always find them in either Article 1 or Article 2 of any state's constitution. In Arkansas, it's called the Declaration of Rights. It's in Article 2. Article 1 is just about like geographic boundaries for the state and things like that. One thing I would ask you to do is please read your Arkansas Declaration of Rights. I think you're going to be surprised at all the things you find in there, all sorts of wonderful enumerated protections that don't exist in the federal Bill of Rights. It won't take you that long to read it. The Constitution in general, the Arkansas Constitution in general, is a very long document because it talks about like how to create a municipality and how to dissolve a municipality and all sorts of minutiae you don't care about. But the Declaration of Rights isn't that long. You know, you can read it in a few minutes, and I think you'll just be blown away by these protections that you have in Article 2 of the Arkansas Constitution that you probably didn't even know existed. And so what happened, right? So we had the federal constitution to limit the federal government.
Sorry to interrupt. We've got a few questions in the chat box real quick before we.
You want to? Yeah, I can cover questions before we move on.
Sure. Yeah. So this first one, does the fact that the states fall under implied powers leave more room for interpretation where the federal delegated powers don't?
Well, so the way it works is it's not that it leaves more room for interpretation. So the way the federal constitutional structure is set up is assume that the states are governments of general powers. Because as far as the original federal constitution was concerned, they already had state constitutions, so the federal constitution didn't have to deal with them. But then you have state constitutions that limit the state and local governments. And when it comes to interpreting those powers, in theory, the analysis should be similar, right? In theory, you have constitutional provisions where you're interpreting the text of that provision and the public meaning of that provision and the precedent applying that provision. But in practice, what I will tell you is oftentimes state governments are given a little bit more leeway. By the implied powers, you might be talking about the police powers. And it's understood that state and local government, and the federal government now too, to a degree, but really historically, state and local governments have what were referred to as the police power. So the power to protect public health and safety. And when public health and safety is concerned, the courts tend to be very deferential to the government, maybe even overly deferential. And so what ends up happening is it's possible that in some situations, particularly when you're dealing with implied powers and police powers, you're going to get a little bit more deference towards state and local government. But it really just depends on kind of the situation and the facts and what clause you're litigating under.
Great. And then the other question was about your Ken's Cab case, but the question was, did the City Council of Little Rock also regulate the prices for yellow cab in the area?
Yeah, they did. If memory serves, they did have some sort of price regulation, and Ken agreed to follow that, so that wasn't really an issue. And I'm going to talk about Ken's case a little bit more later, so if you have any more questions about Ken's case, we'll see if I cover it at the end, and if I don't, then please feel free to ask away.
Awesome. Sounds good. Well, that was what we had in the chat, so.
Remember to put your statements, your questions in the chat, and Tara will ask Justin along the way.
Sounds good. And so, yeah, so basically for the first century of our nation's history, a little under, the federal constitution limited the federal government, state constitutions limited state and local government. And then, of course, came Reconstruction and all the horrors that went along with it. I'm sure most of you know, the 13th Amendment abolished slavery, thankfully, but it didn't do enough. In the period right after the 13th Amendment and right after the Civil War, we saw horrible abuses, mostly in the South, but elsewhere as well, where laws called black codes were passed that were designed to terrorize the freedmen and their allies. Oftentimes, and there were many issues, but one of the big issues had to do with deprivation of economic liberty. Licensing laws were created to make it so that former slaves couldn't get certain types of jobs. All sorts of crazy laws were created involving contract law, so that you'd have situations, like there were some famous situations in South Carolina where people who used to be slaves ended up inadvertently violating these bogus laws and being ordered to work for free for their former slave owners. I mean, just horrible, horrible things that frankly resembled de facto slavery. I mean, and so technically after the 13th Amendment, slavery was abolished, but functionally, there was something a lot like it going on in some parts of the American South. It was absolutely horrible. Unfortunately, the elected state court judges were not much help. And neither were the federal courts. Not only did most of the US Constitution not really apply to state and local governments at that time. But even when there were opportunities for the federal courts, they didn't do what they should have done. The most famous and perhaps the most notorious example of this is the Dred Scott case, where in 1857, the US Supreme Court ruled that the Constitution did not protect African Americans and African Americans could not become citizens, which is absolutely horrible stuff. And so because of Reconstruction and all of the ridiculous abuses going on in the South and the violations of rights that we were seeing, that really led to a kind of a dramatic shift in how we see federal constitutional law and its relationship to state constitutional law. And of course, I'm talking about the 14th Amendment. Some of your history teachers, so you know, Frederick Douglass was the most famous person of his time, a former slave. He pushed hard for this notion, correctly, of course, that African Americans were citizens protected by the US Constitution, and Dred Scott was incorrectly decided. He was joined up by a group of so-called radical Republicans led by John Bingham in Congress, and John Bingham drafted the 14th Amendment. And it did several really important things that fundamentally shifted the relationship between state and constitutional law in the country. First of all, of course, it said no more of this garbage that African Americans aren't citizens. If you were born here and naturalized here, you're a citizen and you have the protections of the Constitution. Also, and this was also huge, now those protections applied, that the protections in the federal government applied to state and local governments. So you could go into federal court with an unelected federal judge instead of your local elected state judge who was voted in by the same people who voted for the Black Codes. You could go to an unelected appointed federal judge and apply these protections in the federal Constitution. That's huge. The reason why federal judges are not elected is because the founders recognized that you needed judges who would be willing to stand up for the Constitution even when it was unpopular to do so, and that in fact the most important time to do so was when it was unpopular to do so. And now the victims of these Black Codes could go to these federal judges to vindicate their constitutional rights. As far as the actual protections in the 14th Amendment, of course, the three big clauses, and there are other provisions, but the three big clauses are the Privileges or Immunities Clause, Due Process of Law, and Equal Protection. The Privileges or Immunities Clause, or the PRI Clause, as we often call it for short, was really supposed to do most of the heavy lifting. It basically said that all American citizens, all people born or naturalized in the US, have certain national rights and protections that they're born with and that states can't go below. Due process of law, people often focus on the due process aspect, and that's part of it. But the concept of due process of law is actually something that goes all the way back to Magna Carta, and it has to do with the fact that there are certain things that have to happen before a legislative act can be considered a law. And so not only do you have to be able to seek redress in court, but the law can't be arbitrarily created, it can't be unreasonable, it can't disrespect your natural rights, and then you have to have a place to go to in court with fair due process to be able to argue that those things have happened. And then finally, of course, equal protection. Similarly situated people must be treated similarly by the law. And so, we just had this sea change in constitutional law back when the 14th Amendment was ratified in the late 19th century. And all of a sudden now, instead of going maybe feudally, depending on who you were, to state court to assert a state constitutional claim, you could go to federal court and assert a claim under the 14th Amendment in front of an unelected federal judge, and no one could say that you weren't a citizen, even if you were a former slave. And so this was huge, but unfortunately, things didn't go as planned. When I think about what went wrong with the precedent applying the 14th Amendment, it actually reminds me of one of my favorite quotes from the founding. When James Madison, after the deal was made between the Federalists and Anti-Federalists to create a Bill of Rights, when James Madison presented the Bill of Rights to Congress, he promised that the judiciary would be, quote, an impenetrable bulwark against every assumption of power in the legislative or executive. And I think about that a lot, as someone who goes to court asking judges to rule laws unconstitutional. I love that quote. I love thinking about courts as these impenetrable bulwarks against government abuse. On the one hand, the founders recognized that, government was a necessary evil. You needed some of it, but it also tends to want to grow and expand and go beyond its limits. And so then on the other hand, you've got these impenetrable bulwarks, these federal judges keeping government from expanding past the limits created by the Constitution. But what's the problem with that? The problem is Federal judges aren't impenetrable bulwarks. I can tell you that firsthand. I talked to them. They tend to be very decent, honest, smart people doing the best they can, but they're human. They make mistakes. You know, sometimes government slips one by the goalie, and government grows. And that's really the story of the 14th Amendment. Because it was such a dramatic shift in the way we viewed the US Constitution, there were quite a few judges, including on the US Supreme Court, who were uncomfortable with that change. And so right off the bat, it started getting watered down. There was a famous case called the Slaughterhouse cases, had to do with slaughterhouses and butcher shops in Louisiana. Right off the bat, in that case, the Supreme Court basically eviscerates the Privileges or Immunities Clause. This was supposed to be the big clause that did most of the heavy lifting, basically read it right out of the 14th Amendment. So then you still have the due process of law and equal protection clauses, but now they're doing more work than they were really supposed to. And over time, they got watered down as well. Of course, by the time you get to the New Deal, you've got the fight between the Supreme Court and FDR, where FDR threatens court packing. Some people believe that led the Supreme Court to change their view of the 14th Amendment. Others don't think that. Other people think that it was because of the landslide election of 1936 and the Supreme Court hated being so unpopular. Whatever the reason, around 1937, the U.S. Supreme Court declares that even for due process of law and equal protection, from now on, some rights were going to be more equal than others. And basically, for the vast majority of rights, they were no longer going to get meaningful judicial review. Some rights still were going to receive that meaningful judicial review, like the First Amendment, the rights that the Supreme Court still cared about. They were going to get what was referred to as strict scrutiny, which meant that facts really mattered and the burden was on the government. But for all rights that the Supreme Court decided were not fundamental rights, and this typically included things like property rights and economic liberty, many of the key things that gave rise to the 14th Amendment, you know, economic liberty was at the heart of the 14th Amendment, but it wasn't a right that the Supreme Court cared about towards the end of the New Deal. Those would receive what's called the federal rational basis test, which is basically a giant rubber stamp. You can win cases under it. I have, but it's ridiculously difficult. It's designed to make it so that the government almost always wins. And so all of a sudden now, at the end of the New Deal, you kind of have this shift back that's been going on ever since, where people who have claims. Is that a question?
I don't think so. I think you're
okay.
Good to continue.
No problem at all. So basically what happened was, from the New Deal until now, you've seen this gradual shift back where you have more and more cases being brought in state court under state constitutions. I should point out, you can also bring both, right? You could bring state and federal claims in either state court or federal court. But I don't want to get too complicated. So let's just say, for the sake of argument, state courts handle state constitutional claims and federal courts handle federal constitutional claims. And you know, you're getting a lot more state constitutional cases now. And so for people like me, for public interest lawyers who are filing constitutional challenges, every time I bring a case, I have to think about whether I want to bring this case under the federal constitution or the state constitution or both. And so it's really important to remember the relationship as it stands today between these two types of constitutions. The first thing to remember is that state constitutions can never drop below the national floor set by the US Constitution, but they can go above it, right? So basically, the US Constitution and the US Supreme Court precedent applying the US Constitution, that creates a national minimum standard of constitutional protection. Then it's up to the state constitutions and their state Supreme Courts to decide whether they want to have the same standard or a higher standard, but they can never have a lower standard. And in making that determination, that's completely up to state Supreme Court. So just like the US Supreme Court is the court of last resort, it's the final word when it comes to interpreting the US Constitution, state Supreme Courts are the court of last resort, you know, the final word when it comes to interpreting their respective state constitutions. It's entirely up to them to agree or disagree with the US Supreme Court. Sometimes they like what the US Supreme Court does and they copy it. Sometimes they come right out and say, we disagree, and they give more protection. They can just never go below the US Supreme Court. It's entirely up to them whether they want to give more protection than the US Supreme Court has. And then on top of those choices made by state Supreme Courts, another cool thing about state constitutions is, you know, as I mentioned before, in the Arkansas Declaration of Rights, Article 2 of the Arkansas Constitution, you can have things that don't even exist in the US Constitution. So this isn't even a question of a state Supreme Court providing greater protection than the U.S. Supreme Court, this is something that doesn't even exist in the U.S. Constitution. And so, as a public interest litigator, I have to look at this and say, all right, do I want to assert state constitutional claims, federal constitutional claims, or both? If the law is the same, like if it's a First Amendment case, I sometimes bring First Amendment challenges. The federal precedent is so strong that the state common law precedent is not going to be any better. And so I'll tend to have better odds in my favor if I'm in federal court in front of an unelected federal judge. But oftentimes the state common law is better, even if it's something like due process of law or equal protection that will exist under both state and federal constitutional law. The state Supreme Court may have a better test than the federal rational basis test, or even if they claim to have the same test, they may have precedent applying it differently, where they said something was unconstitutional, even though the federal court said it was okay. And so that precedent could help as well. And then these state constitutions can have extremely useful provisions not found in the U.S. Constitution. And for what I do, representing small business owners most of the time, this is particularly appealing to me because these provisions oftentimes include specific, express, enumerated protections for the things that I litigate about more often than not, economic liberty and property rights. And these provisions will sometimes include something called an anti-monopoly clause. And that turned out to be a big deal in Ken's case here in Arkansas. So now what I'd like to do is apply these lessons about the relationship between state and federal constitutions to Ken's situation, right? Where he was admittedly qualified. The government didn't deny that he was qualified. He met all the requirements, but they had created a private monopoly for yellow cab and he was simply not allowed to compete. So when I was trying to help Ken out, of course, the first thing I do, because these are the most common types of cases, are due process and equal protection, I looked at the Arkansas Supreme Court's precedent applying the state constitutional due process of law and equal protection precedent clauses, excuse me. And honestly, there wasn't a whole lot there. There were some things, some precedent that maybe was a little better than the federal precedent. We would have had a fighting chance, but the odds would have been stacked against us. So at first it wasn't looking good. But then I had to go on to step two. I had to look at whether there was anything different about the Arkansas Constitution. And right off the bat, I noticed one of my favorite clauses, the Anti-Monopoly Clause. If you want to see it for yourself, it's in Article 2, Section 19 of the Arkansas Constitution. The relevant part says perpetuities and monopolies are contrary to the genius of a republic and shall not be allowed. I'm very familiar with these clauses. We have brought claims under these clauses in other states. They can be extremely useful. It does depend on kind of how the clause is written. By the way, I see a question about utilities. Yeah, so that's a great question. They're kind of treated like their own separate thing. Even though they are technically private, sometimes, usually, they get grouped in with government provided services. And so, for example, anti-monopoly clauses obviously don't apply to when government provides the services. And that's even true if the government is kind of delegating that to another group to kind of work as an agent for the government and provide it in its stead. And utilities kind of get grouped into that, and that's how they're able to get away with it. But what these anti-monopoly clauses typically won't let you do, it won't let the government just say that, hey, you're a private business, you're not a utility, you're not a service provided by the government, you're just a private business, and we're saying no one can compete with you. It actually even goes further than that. Back when these clauses were enacted, monopoly, kind of the legal term of art monopoly, meant something a little different than the common way that term's understood today. It actually covered any type of kind of licensing requirement, right? It didn't just cover where you had one group. It also covered like a duopoly or a cartel. And so sometimes we have to talk about that with courts about kind of the historical understanding of the term monopoly when these provisions were enacted. But here in Little Rock, in this case, we didn't have to worry about that because there was only one. And so under anyone's definition of monopoly, Little Rock had created a private monopoly for yellow cab. And not only did Arkansas have an anti-monopoly clause, but it had one of the strong ones. And so I happen to know from experience that about 20 states, and not just about, exactly 20 states have anti-monopoly clauses, but some of them are worded differently than others. Some of them, frankly, aren't that useful. There was a case in Georgia under one not that long ago, and that one was just not worded strongly enough or applied well enough to really be useful. But here in Arkansas, it's one of the dozen state constitutions where I would say it has a strong anti-monopoly clause, one that's really useful. And so I said, okay, well, great. So there's an anti-monopoly clause. It's written in a way where it could possibly be useful. You know, you're one of the good 12 states for that. Now let me see what the Arkansas Supreme Court has done with this anti-monopoly clause. Well, it turns out that the Arkansas Supreme Court precedent was excellent. It had several cases applying the anti-monopoly clause. They were all correctly decided, in my opinion. In other words, none of them hurt my case. And not only that, not only were all the cases kind of in my favor and consistent with my argument and my view of what the anti-monopoly clause should say when it came to Ken, but there was one that was directly on point. It turned out that back in the 1950s, North Little Rock had a law for taxis that was almost identical to the law that Little Rock had. And that law was ruled unconstitutional by the Arkansas Supreme Court under the anti-monopoly clause. And so I said, all right, we got it. Like, we have a strong argument. We're going to lead with the anti-monopoly clause argument, and we're going to win. And that turned out to be true. In fact, not only did we win, and we didn't just argue the anti-monopoly clause, we led with that, but then we also asserted alternative arguments under due process of law and equal protection. But our anti-monopoly clause, our leading argument, was so strong that the court never even had to reach our other arguments. And not only that, because the precedent from the Arkansas Supreme Court was so strong and the clause was so clearly worded, and the relevant facts of the case had already been admitted, right? Little Rock didn't dispute that it had given all of the taxi permits to Yellow Cab and no one was allowed to compete with them. Because of all these factors, we were actually able to win on something called a motion for judgment on the pleadings, which basically meant that just based off the undisputed facts, we should win because the constitutional violation was so obvious that no matter what they said, it wouldn't matter. We didn't have to do discovery. We didn't have to take depositions. None of those facts mattered. All of the relevant facts were already admitted, and under the state constitutional precedent, we had to win, and the judge agreed. This was at the end of 2016, so a little less than a year after we filed it. The judge agreed that Little Rock had violated the anti-monopoly clause. That became final in early 2017. The city of Little Rock decided not to appeal. And so then what happened was Ken had to reapply. So basically the way it works is that the judge in our Little Rock case ruled that the ban on competition with Yellow Cab was unconstitutional, and that if Ken met all the requirements, then he had to be allowed to compete. And the city had already found that Ken had met all the requirements, but that had been like a year ago. And you never know, things change. And so Ken had to go through the process again and show that he still met the requirements. But he did. He went through that process again. And again, he showed that he met them all. And now he didn't have the anti-competitive rule, the monopoly rule in Little Rock standing in his way. And finally, in kind of mid-2017, he was finally granted his permits to operate in Little Rock. And that was just a great moment. I actually flew up. I'd obviously come to Little Rock for the different court arguments along the way, but I actually flew up for that hearing with city government as well, because I wanted to make sure that nothing went wrong. And so I want to play the video that was created by the footage I took from that trip.
We're about to request the city board to allow me to have taxi permits here in Little Rock.
All right, Ken, we just left the board of directors meeting. What happened?
We won. We got the permits. And I'm so excited. I'm actually going to be able to legally have my business in Little Rock now.
All right, so that was Ken and me celebrating his victory. And if you're in the Little Rock area today, you'll actually be able to call up Ken's Cab if you want to. It still exists. And frankly, it's because your state is a little freer than 38 other states, right? And that kind of takes me to my conclusion. You know, again, I know I keep harping on this, but I can't emphasize it enough. please read your Arkansas Constitution's Declaration of Rights in Article 2. It won't take you very long. You don't need to read the whole Constitution, just read Article 2. It can only help, the states that can't go above the federal floor. They can't go below the federal floor, but they can go above it and do it in different ways. And different state constitutions have different ways that they do it. They have different protections. And if Ken lived in one of the 38 states that did not have a strong anti-monopoly clause, then I think it's more likely than not that Ken's cab would not exist today. And that would be a real shame, right? I mean, this extra competition, it doesn't just help out Ken. He was able to hire more people when he was able to expand into Little Rock. He was able to give more options to consumers, and not just options in terms of service, but he also prided himself on buying environmentally friendly cars, and some consumers like that. And so, at the end of the day, right, it's not the government's job to pick winners or losers in the marketplace. That right belongs to consumers. This win vindicated that both for Ken and for the public of Little Rock. It was just a wonderful thing. And again, in 38 states, it probably wouldn't have happened, but thankfully, Arkansas has an anti-monopoly clause and some good state Supreme Court precedent, and I was able to use it. Thank you very much. At this point now, if there are questions, we have plenty of time to answer them.
Awesome. And we do have one right now in the chat box that I'll just read off. But then if anyone wants to turn on your mic or turn on your cameras, feel free. But the one in the chat box currently is, did the city compensate Ken in any way for the time he wasn't able to work throughout the trial?
No. Well, technically, yes, he got $1. He got $1 in nominal damages. But no, that's not how it works. Unfortunately, governments have a whole series of immunities. And if you think about it, as frustrating as it is, and there are certainly times when those immunities shouldn't apply, and they do, unfortunately. That's another talk for a whole nother time. But at the end of the day, when it comes to these types of economic regulations, governments are exempted from antitrust laws. They're exempted from civil liability, because anytime you have restrictions on people, like that's going to cause financial harm. And if every time one of those were ruled unconstitutional, and if you could get financial damages, it would cause all sorts of other consequences. And so no, what Ken got was, he got a declaratory judgment saying that what happened was unconstitutional and could never happen again. He got injunctive relief, which is basically an order from the court ordering Little Rock to stop doing it, to knock it out. And if Ken reapplies and meets the requirements, to give him his license. And he got $1 in nominal damages. And we actually asked for that $1. It's important to make sure that, we cross all the T's and dot all the I's and leave no doubt that what happened was wrong. And so both, Ken has the check, but in my office, there's actually a framed color copy of the check for $1 from the city of Little Rock.
So we had a follow-up to the public utility state monopolies, basically, for maybe you following or maybe diving a little bit more into that. So how are we only allowed, the question is, how are we only allowed to have one option for utilities if monopolies are illegal? So only one place to get your water, your electricity in most towns. How is this constitutional in any way? Yeah,
so Jeffrey Davidson actually kind of hit on it. But this is kind of a court-created doctrine where the courts, for practical reasons, they thought it would be impractical that there were certain, they had to kind of give more leeway. And so they had to kind of go around, let the government get away with this legal fiction that a utility was really just an extension of a government. That even though it was technically a private company, it was really just an extension of the government, where the government's protection from these types of actions could be kind of extended to utilities. Now, I think, that could be well argued, right? I mean, I think there are times where even if you buy that court-created, practicality doctrine, there are times where it wouldn't apply, and perhaps the courts have gone too far. Maybe they shouldn't have let them get away with it at all. I'm not saying I agree with the court's logic, but that was the court's logic, that utilities are kind of their own quasi-governmental separate thing from other private businesses.
All right, the floor is open. Do others have questions?
That sounds very similar to the post office being also a private business, yet they're afforded government aid, government loans that are so far and above beneficial and all of those different gray area benefits, but yet they're a private business.
Well, the post office isn't a private business. It depends. I mean, there are private businesses, but if you're talking about the U.S. Post Office, that's actually created by the U.S. Constitution. You don't have to have one, but the power to create it is provided in the U.S. Constitution, and it's part of the government. But what I will say is, you know, competition is a wonderful thing, and kind of the post office has had many problems over the years, and frankly, probably the reason why it still exists probably owes itself to competition in large part. You know, going back over 100 years, at one point there was a gentleman named Lysander Spooner who attempted to compete with the post office, and he's actually the one who invented postage stamps and all sorts of other innovations. And then because the post office is subsidized by the federal government as part of the federal government, they were able the federal government just kept pouring money into it, and it was able to undercut Lysander and put his business out of business. And then but the post office did adopt many of his innovations. And over the years, I mean, more recently, you've seen other, you know, FedEx and other companies kind of create their own innovations, and they've been able to survive. And so even when it's kind of a branch of the government, competition is typically a good thing. But even with those innovations that the post office has often kind of adopted from private companies, it still has lots of problems. But the reason it's allowed to kind of exist as, I don't know, I guess you could call it a monopoly, although there is competition. But regardless, the short, I went on a kind of a long tangent there, but the short answer to your question is there's a clause in the U.S. Constitution that says post offices can be created by the federal government. So that kind of exempts them out from a lot of the types of challenges I like to bring. Deborah Harms asks about how my service is supported. And I did say donations. Yeah, we have over 8,000 individual donors from all across the country and all across the political spectrum who pay my salary, our costs, everything. Our clients never pay a penny. We don't ask them to, like, we don't really want them to. We don't want them to feel obligated. Like, we're very, very fortunate, and we have some donors who give a lot, some donors who give a little. We have no donor who gives like a disproportionate amount. Like, it's really spread out among over 8,000 donors, and none of them, and they all realize that they don't really get to have a say over what we do. Like, the legal profession gets made fun of, and I think correctly so. And there are definitely bad actors, but I'm so fortunate that I work in one of the few places in the legal profession where I have the luxury to operate entirely out of principle, and that's because of our wonderful donors. And so, yeah, because of these donations, we can not sue for money. We can not charge our clients anything, and I can just go around trying to help out small business owners who need help. Now, I will point out that there is a downside to that, right? Like, even though we're a very well-funded charity, there are limitations, and people love free legal advice. People need free legal advice. And so for every case that I take, there are many that I don't. And that's actually one of the worst parts of my job, is I have to tell so many kind of deserving people that I can't take their case because I can only take so many. And so in those situations, we try to set them up with private attorneys who are willing to do pro bono work and things like that. Sometimes we're able to, sometimes we're not. But we try our best because there is just such a demand, but we do what we can to take as many of them as we can. And there's actually this whole internal process at IJ where we vote as a team over which cases to take and not to take. And it can be heart-wrenching sometimes, but we're just so fortunate we're able to take as many as we can because of our donors. Let's see. So Jeffrey Davidson asks about monopolies that are national. Theoretically, could a monopoly that has its operations across the nation be considered illegal in our state due to this provision in our state constitution? Yes, it could. It could also, there are quite a few different ways it could get in trouble if it's a true private monopoly. Like, first of all, of course, you have federal antitrust law, okay? And then you also have, in some states like Arkansas, anti-monopoly provisions, so they can apply to a private company, even if that private company has operations elsewhere, right? So they could still apply. You can't apply it to their operations in those other states, but you can apply it here. And then you often have state antitrust laws that are also true. So if you have a monopoly where there's proof that it's a monopoly, the fact that it's national doesn't protect it. If anything, it just increases the number of laws it might be violating. Let's see.
So
So are
another,
big businesses donors to help IJ defend small businesses? Not really, not that I'm aware of. I mean, I don't know all 8,000 of our donors. There might be some that are big businesses, or some hopefully own big businesses or something. But generally speaking, big businesses tend to not like me because oftentimes what happens, I don't know how many of you guys have studied public choice economics, but there's this dynamic where usually when I'm challenging a law, it was a big business that pushed for that law, and I'm representing the little guy who's not as politically powerful. And so, so many people have this misperception that it's government versus business. That's sometimes true. That's often not true. For my types of cases, more often than not, what it is big business weaponizing big government to hurt the little guy. And since I'm representing the little guy, big business doesn't like me very much and wishes I would go away and let them continue to run things. So maybe there are some owners of big businesses or big businesses that donate to IJ, but I don't know about them. And frankly, I tend to not be popular with them.
So I love the Little Rock example. That was fabulous. We are going to give every participant a choice of 2 books. And Tara, I don't know if you identified them or Justin. Do one of you
Justin,
want to?
I asked Justin for some recommendations. And we included both of them. So the Clark Neely piece, and I can't remember the second off the top
So
of my
I'll
head.
talk about them.
Sure.
So the one that's most relevant for my talk today is called 51 Imperfect Solutions. It's a relatively recent book written by a federal appellate judge named Judge Jeffrey Sutton. And the reason why it's called 51 Imperfect Solutions, right, because it talks about the 50 state constitutions and their relationship with the federal constitution, kind of the same topic I talked about today. And so I would strongly recommend that book if you're interested in state constitutional law. And then if you're just kind of interested in constitutional law in general, whether it's state or federal, and kind of the work I do, there's another incredible book called Terms of Engagement by Clark Neely, who's a lawyer who used to be a colleague of mine. Now he works at K12. And it's written in plain language for non-lawyers to talk about kind of how judges are supposed to operate, kind of their duty, under the Constitution, whether it's state or federal, and how sometimes, unfortunately, they're not fulfilling that duty and letting the government get away with more things than perhaps it should be. And so, if you care about constitutional law generally, and you kind of want to really hear some great stories and have it broken down for you, Terms of Engagement by Clark Neely is wonderful. If you're really fascinated in this specific subtopic of state constitutional law, then there's no better book than the recent book by Judge Sutton, 51 Imperfect Solutions.
We had another question. Someone asked if you always knew you wanted to do constitutional law, or what did that look like for you?
Yeah, thanks. That's a great question. So no, I studied business. I studied business management as an undergrad, and I thought that's what I was going to do. I wanted to be an entrepreneur. My mom is a small business owner, and so I kind of wanted to be an entrepreneur like she was. I was also toying with the idea of getting an MBA. But while I was in getting my bachelor's degree in business, I kept seeing all these issues that my mom was running into, and other relatives and friends of ours who are small business owners. And I just got so fed up. I saw that, the government had its army of lawyers and the giant businesses had their army of lawyers. And there didn't seem to be a giant army of lawyers to help out my mom. Like there were some public interest groups that existed, but there weren't enough of them. So late in college, I took the LSAT the very last time where I could take it and still apply to law school without having to sit out a year. I suddenly decided I wanted to go to law school, and I was going to start my own practice representing small business owners like my mom. And that's what I did. I went to law school at the University of Miami, graduated with honors, worked for a firm for 3 years because I realized that I shouldn't hang up a shingle right out of law school. So I worked for a firm that promised to let me get a lot of trial experience from the get-go. After 3.5 years from that, I started my own practice representing small business owners. My mom was my first client down here in South Florida. I built it up. I had it for 7 years, had other lawyers working for me, but I became and so now we're talking like 10 years into practicing law before I became a constitutional lawyer. I became increasingly frustrated at what I was seeing, and I had this feeling like I wasn't fixing anything. And that's because my clients couldn't afford to pay me to file some grandiose constitutional challenge. And so I was just performing pain management and just kind of helping people deal with these issues on a shoestring and just getting the same calls over and over again from different clients with the same problems with their local governments. And so finally, I got so fed up that I started doing pro bono work on behalf of food trucks, trying to get Florida cities to get rid of their food truck bans. And while that happened, and again, this is like 10 years into my legal career, about 9 years ago, IJ, the firm where I work now, opened up their Miami office. And so I called them up and I said, hey, let me tell you about this food truck stuff I'm doing. I know this is really your thing. If you want it, you can have it. Maybe I'll help you out, but I'll go back to just focusing on running my law firm. And to make a long story short, that created a relationship where about a year later, I was closing down my practice and becoming the Florida office managing attorney at the Institute for Justice. And it was one of the best decisions I ever made, second only to, marrying my wife, who allowed me to do this for some reason, where now, I get paid a salary to work full time doing the things I used to do for fun as pro bono work. And I think that's a wonderful deal if you can get it. And that was about 8.5 years ago that I joined IJ. So yeah, if you want to be a constitutional lawyer, like don't do what I did. Don't open up your own practice and then have a constitutional law firm open up a firm in your backyard. Like that's probably not going to work out. I have an unusual story. Most of my colleagues have a more traditional story. They went to a top law school. They, no offense to University of Miami, or went to law school, but a lot of them went to like Harvard and Yale and stuff. And they clerked for federal judges. Some of them clerked at the U.S. Supreme Court, worked for big law for a couple of years, and then transferred back to IJ. That's kind of the more traditional approach. I'm kind of a little different, but it worked out.
Well, it's been fabulous. And I see lots of wonderful comments popping in the box. I think people want you to come back and talk to us again about something different. So you and Tara can work that out.
Definitely. I do want to highlight one comment. So Chris, I don't know if you're still in the webinar, but Chris said, this was very interesting. I didn't know that that someone was doing what you do, like that this job even existed. And I'm so happy you said that, Chris, because I will slightly brag on Justin one more time before you are all away from me today. But Justin speaking about the work that he does was the first time I think I really heard someone talking about their job or presenting and say, okay, like now I totally understand like what a lawyer might get up and do throughout the day. So like I have a background in history. I'm sure several of you have a history background, and that is always an option that you think of. You're like, I'm going to take the LSAT, see how I do, go from there. But what does that mean? What does the actual practice and application of studying laws and understanding, different states require different things and all of the steps in that process? I think this presentation does a great job highlighting just the research and work that you do. And I think students might be able to also enjoy that. So seeing this is, your first step where you start, and then this is what you do next, and this is your backup plan. I think students having examples of professionals doing that and having those skills in the workplace is great to highlight. So thank you, Chris, for pointing that out.
Oh, well, Tara, thank you for your kind words. And I just want to echo that, it's so much fun to have like the picture with Ken where he gets his permits, or to be walking out of the courthouse and the judge said that you won. But that's not a typical day, right? For each one of those moments, there are hundreds and hundreds of hours of like tedious research. And I love it because I understand the goal. But, it's just so much work. And it really, if you want to be a lawyer, especially particularly a constitutional lawyer, you have to be the type of person that loves to read. You'll probably have to start wearing glasses at some point, like I have. Like you just read and you read and you read some more. You look under every possible rock. You read every state constitutional provision, every federal constitutional provision, every case applying any of them. Like it takes forever. But if you work hard enough, then you find something that you can use and Ken gets to start his business.
Fabulous. Thank you all for joining today. And thank you again, Justin and Tara, for making this possible. If anybody has any questions, unmute yourself. If not, we're going to let Justin go about his evening.
Well, thanks, everybody. And thank you again for having me. This was a lot of fun.
Thank you.
Yeah. Thanks, Justin. All right. And we're going to share that one more time.